I'm Zhao Jun, a law professor from Guanghua Law School, Zhejiang University. My paper is about human rights accountability of transnational corporations, a potential response from bilateral investment treaties. In the modern globalized system, transnational corporations have been rising in economic, social, and political importance. Recently, there has been a growing body of evidence that the impact of transnational corporations' activities in developing countries can result in violation of human rights or act as a catalyst for violation of human rights. Human rights protection traditionally focus and impose duties solely upon states. This singular focus has led to a breakdown in the protection of international human rights in recent decades. The systemic separation between international economic development, human rights enforcement, and the regulation of private players leaves power to commit human rights abuses in the hands of non-state actors. The rapid expansion of transnational economic activities and the corresponding growth in the power of transnational corporations has prompted international discourse and actions to address the human rights violation committed by transnational corporations. The goal of this research is to explain why and how bilateral investment treaties could be drafted or amended in order to enhance transnational corporations' human rights accountability. This paper is composed of 6 parts, including introduction and conclusion. Part 2 will analyze the rationales for holding transnational corporations liable for human rights violations. The rationales include the need to rebalance state power to regulate transnational corporations in the public interest, the need for compatibility between transnational corporation power and accountability, and transnational corporations have competency and can be incentivized to protect human rights. Part 3 will take stock of existing legal institutions regulating transnational corporations. Indeed, there are already many legal instruments, including soft laws and hard laws, in regulating transnational corporations, both at international and domestic levels. Part 4 will examine the difficulties and hurdles in subjecting transnational corporations to human rights liability. These difficulties and hurdles include the lack of legal basis for holding transnational corporations liable at international level, lack of incentive or competency of host government and home government, the race to the bottom issues, the lack of international organization with sufficient competency, and other disincentives and technical barriers. Part 5 will probe into potential advisable proposals on how bilateral investment treaties should be reformed, both in substance and procedure, to better respect human rights. The major form of transnational corporation economic activities is investment, and the main body of international investment law is a web of BITs, agreements for promoting foreign investment in a specific country. While the interests of foreign investors can sometimes collide with the human rights of those living in the host state should be able to justify the measures based on its human rights obligations in order not to avoid liability for breaching its obligations under BITs. An innovative idea is to incorporate human rights obligations into BITs, as this would be an effective and efficient way to impose obligations directly upon corporations by international law. International investment agreements contain a social dimension, as foreign investment directly impacts social, political, and environmental issues. Consequently, international investment law should be reconceptualized in order to realize both the economic and social aspects of foreign investment. Indeed, given the increasing and widespread use of BITs and their effective dispute settlement mechanism, it may be possible for states to revamp the present BIT regime to better accommodate public interest and human rights. States could accomplish this goal by either amending existing BITs, negotiating new BITs, or interpreting certain BIT provisions with binding force. In addition, human rights obligations, as well as treaty-based compliance mechanisms, could be introduced into BITs and other international investment agreements. Thank you.